Ms. Thomas?
Good morning, Your Honors. May it please the Court, Ann Thomas for the Commonwealth. And with me today is Assistant District Attorney Josh Wall. We're here today to ask you to affirm the trial court's order denying the defendant's motion for a new trial. The only issue at hand is whether the inclusion of the erroneous, grievous bodily harm language in the judge's instruction on the third prong of malice created a substantial risk of a miscarriage of justice. Here, the likelihood of fatality posed by the defendant's conduct was such that this error did not create a substantial risk of a miscarriage of justice. Specifically, the defendant stood outside of a car next to the open front passenger side window of a car that contained 3 passengers. The victim was in the seat next to this window. The defendant pushed down the door lock with his right hand. He put his left arm on the windowsill over the lock. As the argument progressed, he then raised his right arm off of the windowsill. He pulled a loaded gun from his waistband. He cocked the hammer. He pointed it in the open window during a heated argument, and he shot the victim in the mouth. As most recently stated by this Court in Commonwealth v. Russell, in numerous cases positing the identical error in the definition of third-pronged malice, this Court and the Appeals Court have concluded that where the conduct in question posed a risk of harm that was not less than a plain and strong likelihood of death, the error is non-prejudicial.
Well, but I take it that the argument, of course, is that the jury could well have found that he had no intention of pulling the trigger, didn't intend to pull the trigger, that the trigger was pulled only after the gun was struck, and that in those circumstances, a risk less than a plain and strong likelihood of death might have been present. And but the way the instructions were structured, that would still lead them to a second-degree murder verdict. I mean, isn't that the argument? We just can't look at your best case.
That is the argument, but we disagree on 2 points. One, that argument ignores the fact that the jury was instructed on accident more than once. This point was also pointed out in the Russell case. So therefore, that the jury were instructed that if the Commonwealth did not prove that this was a result of an accident, that they had to find the defendant not guilty.
Were they instructed on manslaughter?
Yes, they were.
Involuntary?
Yes, they were.
Well, wouldn't it pertain to that more than accident?
Well, I think the accident instruction is important to note. But as far as, yes, the difference between involuntary manslaughter versus the third prong of malice, the difference, again, is malice. And that, again, is the degree of harm. Here at issue was never the degree of harm if that gun went off. It was the likelihood.
The issue is not malice. The issue isn't the issue reckless conduct? I mean, here he points apparently a cocked revolver, handgun, whatever it is, into the car, and then he claims it got struck, as I understand the facts, and it went off. Possible accident, but more likely than not, the result, at least the defense says, I think, of the bad consequences of a highly reckless act, which would be involuntary manslaughter. But this grievous harm thing seems to take that out of the equation altogether, take away the manslaughter verdict.
I don't believe it does. Again, based on the case law, like you have Vizcarrando, which again, and
yes, but those are not very helpful. I mean, these are also fact-specific, and what I have to, in a sense, overcome is that appeals court, after careful review of the trial transcript, I'm quoting from the appeals court, I haven't done a careful review of the trial transcript, but I assume that court did that. We conclude that the following circumstances from the testimony and evidence, if believed by the jury, could reasonably have resulted in manslaughter. And one of the things they point to is that he said he was aiming a gun to prevent the confrontation from escalating. So I think Justice Glaney is correct. It's not accident. It's recklessness. In other words, I can think of circumstances where there really is a confrontation escalating and somebody trying to, pulls out a gun and says, quieten down, and stops the confrontation. But if you have this kind of a jury instruction, don't you remove from the jury's consideration a conclusion that would result in a manslaughter verdict?
No, again, at issue here is the inclusion of serious or grievous bodily harm in the third prong malice. So again, I don't believe that that specific error in the context of how this case was tried would have removed involuntary manslaughter from the jury's consideration, because again, the issue would have been on a third prong malice whether it was like a plain and strong likelihood if this gun went off that someone that.
Well, if you're pointing a gun, I mean, as I take it, I'm just trying to get a handle on the facts. The appeals court also pointed out the fact that the defendant asserted that he did not place the gun directly to the temple of the victim. No question, if you're doing this, that's one thing. But if you are pointing generally, why is that? Does that necessarily mean that there's a plain likelihood that death will result, plain and clear likelihood?
Well, I think the decision in Jenks answers that, Your Honor, and the court held that, again, firing in the general direction of a person is nothing less, does not create a risk less than a plain and strong likelihood of death. And then again, we have the Nyland
If you're
case.
firing in the general direction of a person, but assuming that this man is saying, I'm not firing in the general direction of a person, I'm pointing a gun into the car, the jury needn't believe that it's even pointed towards any particular person.
Well, again, from a very detailed review of the transcript and the defendant's testimony, he's asked after he pulls the gun, where does he put his hand? He rests it back on the windowsill. So this is an open front passenger side window of a car, and there's 3 passengers in the car.
And
I don't think
within-
that that's much different than firing into a crowded dance floor.
And that's within feet of the passengers. And
Definitely.
Now, didn't he say that his hand slipped?
No. His testimony is that the victim, who was pretty much out of it through this whole confrontation, that his hand, and he said it must have been his hand, but that something either hit the defendant's hand or his gun, and that the gun went off. But again, in the context of this being a question of whether there was a substantial risk of a miscarriage of justice, the case as a whole was there was 2 other witnesses, the passenger in the back seat of the car and the passenger with the driver, who both testified that the gun was hit away, but that the defendant re-aimed, and then the gun went off.
But did the jury have to, again, I understand that you're looking at a substantial risk, but did the jury have to accept that evidence? What was the strongest evidence that the gun had been knocked, that he didn't re-aim?
What's being said is you've got to approach this whole thing from the best evidence for the defendant, not what you're telling us,
I
which is the
understand.
best evidence.
Well, is
for
that
the
correct in a
Commonwealth.
substantial risk of justice?
That we have to look?
Oh, you have to look at the entire case on the best facts that the...
No. I believe that under substantial risk of a miscarriage of justice standard, and what was stated in Russell, is that this error has to be looked at in the context of the entire trial and how it was tried. The other thing I think is important for me to note is that I do disagree with some of the appeals court's findings as to how this case was tried, and
Okay,
also
that's what I need.
and
because-
also the defendant's assessment of the case. It's very clear that, and again, this court, during the direct appeal of this conviction, in affirming that conviction, this court stated that the only factual issue was whether the defendant, I have the quote, whether the defendant, the only factual issue was whether the shooting was intentional, as the Commonwealth alleged, or accidental, as claimed by the defendant. The defense, in his opening, the most telling statement was, the question is, can the Commonwealth prove beyond a reasonable doubt this was an intentional act? Then in the defendant's testimony, there's never any questioning about, so did you anticipate that maybe someone would be seriously hurt, but you didn't anticipate someone would die? I mean, it was just not argued that way. His whole defense was that this was not an intentional act and that he was not criminally responsible. It says here in the defendant's closing argument.
When you say not criminally responsible, you don't mean insane. You mean
Civil, sorry.
You mean that it was an accident.
Yes, that he, in his closing, defense counsel goes into great detail about civil versus criminal responsibility. And I quote, nothing that even approaches the standard of proof beyond a reasonable doubt that would allow you to conclude the defendant is guilty of any crime, criminal offense, whether murder or manslaughter. And then in the last sentence of his closing, he says, Thomas Childs is not guilty of either murder or manslaughter. There was this was not how the case was tried. The defendant, and my brother says that the defendant not only claimed that it was accidental, but that he also didn't realize the type of harm or the degree of harm that could happen. That was just not part of this trial.
Mr. Thomas, can I just ask you a couple of things? One is, I take it that the trial judge, the motion for a new trial judge, was really relying on those cases that said that malice can be inferred from the defendant's use of a deadly weapon, correct?
That is part of her, yes.
And then the appeals court says there was, where was it here? This is on page 7, record appendix, page 37. We distinguish the cases on which the motion judge, appeared to be relying, because here there is significant evidence the defendant did not intend for the gun to fire. To fire, thank you. And you're saying that if we look at the record, that statement doesn't withstand scrutiny?
No, I do believe it was the defendant's contention that he never intended to fire the gun. That was his defense. But the cases, and especially Nyland, which I don't believe I've spoken about yet, in Nyland, that was the case where the victim was shot in the face about 12 inches from her face as she was lying in the bed, and the defense was that the defendant didn't mean to fire the gun. He was cleaning it. He actually gives several explanations, but it all had to do with that he did not intend for the gun to fire. And in that case, this identical error was found not prejudicial.
That was, I think in Nyland, the defense was accident.
Yes.
So is it your position that this is either accident or murder?
Well, I'm sorry. I shouldn't say that I think Nyland, that the defense was accident. I think it was the same thing, that he didn't intend for the gun to go off. I'm sorry, and what was your question?
Well, I think Nyland was different because he said he was cleaning his semi-automatic weapon, right?
Yes.
And so that's a classic accident. In other words, this defendant is not saying, I didn't point the weapon. I mean, he didn't say, I was cleaning it thinking it wasn't loaded, and that's classic accident.
Again, I think a difference between the cases where this Court, I'm reviewing this identical error, has upheld it versus where they reversed it. In several of those other cases, one of the other issues that compounded the error was that the prosecution, in its closing, invited the jury to find on third-pronged malice. In this case, from start to finish, the prosecution whole argument was that this was an intentional firing. At no point did the prosecutor ever invite the jury to consider third-pronged malice.
Now, the trial judge here was not the motion for the new trial judge, correct?
No.
Okay, so we're all looking at the same cold record.
Yes, we are.
Just in terms of the sequence,
Yes.
the defendant conceded he had the gun out, and then there was a separate step of cocking the gun.
Yes. He pulled the gun from his waistband, and then he cocked it.
Was the manslaughter instruction given at the request of the defendant, or was it the judge's own?
Actually, it's difficult for me to tell from the record. I went into that in a lot of detail because there was no discussion on the record in the transcript about the different jury instructions and what was going to be given. If there's, this is an older case, I'm not sure if I could have found a written submission.
There was probably a lobby conference, which there used to be many of, right?
There's definitely nothing in the transcript as to who requested it, but he was instructed on voluntary and involuntary. The other distinction I think is important to make is, again, the issue before the Court is whether this particular error, which was the inclusion of the grievous bodily harm language in the third prong of malice, whether it removed the option of involuntary manslaughter from this jury, and I don't believe that it did. If the jury could have made the determination whether, again, under what this person knew, which again is a person experienced with the handgun, whether that was a plain and strong likelihood of death or whether it was wanton and reckless conduct. Not, again, by the amount of injury that would have resulted if the gun fired, but by the likelihood of the gun firing in such a situation.
Did the jury come back with any questions?
They did come back with a question about the difference between murder and manslaughter. Again, the incorrect instruction was given.
Oh, yeah.
I see that my time is up.
Thank you, Ms. Thomas.
Thank you.
Mr. Rosenfeld?
May it please the Court, my name's Arnold Rosenfeld.
What was the theory of the defense at trial?
The theory of the defense at trial was that this was an accident. And that
Okay, so if this were an accident, then how does an instruction on third-pronged malice affect that defense?
Well, it affects that defense because the charge had to be given to the jury on manslaughter because of the evidence. The state of the evidence required that a charge be given to the jury on manslaughter, and an erroneous instruction was given to the jury. As a result, we can't tell whether the jury applied the erroneous instruction in deciding whether there was second-degree murder. There was evidence provided more than what's been discussed.
But the judge instructed, correct me if I'm wrong, twice about accident, is that right?
He did, but he also instructed, he also gave the third-prong malice instruction erroneously twice, because the jury came back, as the other Judge Spina pointed out, the jury came back and asked, what's the difference between malice, between second-degree murder and manslaughter? Can you please re-instruct us on malice? And he gave them the same instruction again, using the term on third-prong malice that either death, whether the result would be either death or grievous bodily harm. It seems to me that goes right to the heart of the case as to whether or not how the jury was going to decide this case. It's based on whether or not there was a viable basis on which the jury could decide that there was manslaughter in this case, whether it was wanton or reckless conduct to hold this gun in the window of the car, cock the pistol, as Justice Graney pointed out. That's wanton, that could be very well be wanton or reckless conduct.
Why wouldn't the result of that conduct be a plain and strong likelihood of death in this context?
Because, as the appeals court pointed out, there was significant evidence that it was an accident.
No, but that's not, I think that this is the point. The point is, yes, the jury's found that as best they could find in your favor, that the defendant created a situation which involved a plain and strong likelihood of grievous bodily injury, and that is the gun would go off into point blank into a car with 3 people in it. But why would the consequences of that be anything less than a plain and strong likelihood of death?
Because if you look at the testimony was, number one, the assistant district attorney pointed out that there were other witnesses who testified that he hit his hand. I think they were witnesses of the Commonwealth. The person in the back seat. When the person in the back seat testified at this particular trial, it was a second trial, he was impeached by his testimony from the first trial and statements he'd made to the police right at the time that he really never saw anything. Yet he testified in the second trial that he saw him not only knock the hand away, but that he put the gun back in.
Well, let me just put it this way. Maybe I'm missing, maybe I'm not being clear. Let's assume for the moment that the evidence was that your client came up, same posture, and shot 2 feet or 1 foot from a car window right into the car, but did not intend to kill anybody, did not intend to, inflict any grievous bodily harm, but someone dies. Wouldn't we say that clearly this would meet the proper third-pronged malice test?
But you're leaving out the critical point, which is there's an alternative theory here, and that's the alternative theory is that when the victim, the so-called victim, struck or touched the gun, that's the theory, that the victim touched the gun went off. There was expert witnesses.
They created by carrying a loaded and cocked revolver and putting it right into a car, in essence, That creates the risk. What are the consequences? There's no risk if the gun doesn't go off. There's no harm if the gun doesn't go off. But if the gun goes off, it can also create a plain and strong likelihood of death. Isn't that the sort of the argument?
I would suggest that, I would differ with that, and I think that what it would do is it would create, it's reckless conduct. I don't think there's any...
It's clearly reckless conduct. Okay, that can meet this standard.
It's similar, if you look at the Pichardo case, Commonwealth, the appeals court case where Chief Justice Warner wrote the opinion.
He thought it was an unloaded gun. That's very different.
That's not very different, actually, because in that instance, that was the theory, was that he thought it was an unloaded...
Mr. Rosenfeld, let me see if I can work through this, and tell me when I'm going wrong. I take it, if I follow the appeals court, that what the appeals court says is the following. There was a claim here of accident. In Russell, there was a claim of accident. In Russell, the claim of accident was, it was an accident pointing the car at the victim. The jury rejected that. Okay? What the appeals court seems to be saying, correct me if I'm wrong, is even if the jury reject that it was an accident, it is nevertheless possible to return a verdict of manslaughter, which is compounded in this case because presumably when the jury came back and asked about the difference between murder and manslaughter, presumably they had already rejected in their minds accident. Correct?
That's correct, Your Honor. And it seems to me that the reason why the appeals court made that finding was that they, in looking at the record, they came to the conclusion that there was a significant, viable case presented by the defendant that the jury never really had a chance to consider as far as third-pronged malice was concerned, because they were presented with it could be either death or it could be grievous bodily harm.
There's no question, I take it you would say, that if the facts in fact played out as the way the defendant was, assuming that it's not an accident, that at very minimum there was a substantial risk of grievous bodily harm, correct?
Absolutely.
And you're saying that but that doesn't necessarily translate into a substantial risk of death.
Exactly.
As opposed to Russell, where it's if you are hit by a car traveling at relatively high speed and you are walking along the side of the road, there is no real substantial risk of grievous bodily harm.
I think that's true, and if you look at the facts in Russell were that the defendant in the case drove up over the sidewalk after the victim in that case, left the scene, and then came back later and tried to move the body over closer to the sidewalk so that it would appear that it was just an accident because she was close to the street.
My problem is this. Would you agree with me, maybe you don't agree with me, that if we had the same erroneous instruction, but the facts were that the defendant approached the car and fired directly into the car, 3 people sitting in the car, but didn't intend to kill or hurt anybody, that this instruction would be viewed as harmless error? Because if you point a gun point blank into a car and shoot, you have created a plain and strong likelihood of death.
If you point a gun directly at a person...
In the car. No. 3 people in the car, you point it directly into the car and shoot.
No, then I would
just create a plain and strong likelihood of death?
No, I disagree with you because you might hit nothing while you might hit a seat, but it clearly is reckless conduct on the part of a person to do something like that, but it's not necessarily lead to the conclusion that there'd be death.
Isn't the key distinction here between that question and the case we have here is that a third party, at least according to the defense, caused this gun to fire when he hit the defendant's hand, according to the defendant's testimony. That being so, you could find manslaughter.
That's correct.
And the jury obviously were zeroing in on that with that question at the end.
No, but isn't it irrelevant what happens after one points a loaded gun into a car with 3 people in it?
Put it this way, Mr. Rosenfeld. If the jury had been correctly instructed, okay, plain plain and strong likelihood of death, correct third-prong instruction, and had come back with murder, and the defendant were arguing insufficiency of the evidence, we would likely say no, because the jury could find that this created a plain and strong likelihood of death. Am I correct?
Right.
And you're saying what you need to do is to have the jury make that determination because there is a reason to believe that you can point a loaded gun into a car and create only a plain and strong likelihood of grievous bodily harm.
Exactly. It's the jury that has to make that determination, and when they're given an erroneous instruction, as they were in this case and as they were in Picciotto, then they don't get to make that determination correctly. They don't have a correct instruction. We presume that juries listen to the instructions that judges give them, and it's especially important here because the jury came back asking, what is the difference? And they were told incorrectly, again, here's what the difference is. Here's how you make the determination on the third prong of malice.
May I ask, do you attach any significance to the fact that not only did he point the gun, but he cocked the gun? That's a separate step, isn't it?
It is a separate step.
Does that mean this is business here? When you cock the gun, a bullet's supposed to come out, isn't it?
Well, only if you pull the trigger is a bullet supposed to come out. And by cocking a gun, and his explanation, which was supported by other evidence, but his explanation was he cocked the gun in order to make a point that he was trying to de-escalate the situation.
No, but you have to overlook that, because if he says I didn't, that's why I find the discussion of intention not helpful. Because if it's not intention, then I am under Nyland or whatever it was, namely accident. But here it appears as if the jury were out beyond accident. So I have to conclude as a matter of law that pointing a loaded gun into a car creates only a plain and strong likelihood of death as opposed to grievous bodily harm.
If you want to affirm this, but my point is that pointing a loaded gun into a car doesn't necessarily create a plain and strong likelihood of death. It creates a plain and strong likelihood of death or of grievous bodily harm.
I understand.
And if that's the case, and somebody tells the jury, though, that they can infer malice from either of those two,
I understand.
then the jury's going to come up with the wrong, or may come up with the wrong decision. But we don't know here, and when we don't know what the jury based this decision on, it should go back, should be reversed, and it should be given back. He's entitled to a new trial under Azar and Vizcarra.
When the defendant pointed the cocked gun into the car, was there any dispute in the evidence as to who he was pointing it at or how far away it was from the victim's face?
I don't know what the state of the evidence is on that.
Isn't that critical? Because in other words, if I am, and I think Justice Cowan asked this question, if I am pointing a loaded, I know it's loaded, that's Justice Allen, I know it's loaded, and I am pointing it directly at a person, happens to be in a car.
I believe that the evidence is that he was pointing the gun into the car. It isn't, I don't know that whether the evidence is specific as to whether he was actually, I don't believe there's any evidence that he was holding it to his head specifically, but that he was pointing it in the car.
Well, I guess the point is, by doing that, by putting the loaded, cocked gun, if in fact the evidence is, pointed at one person, created the risk it would go off. If it went off, there's no question that the result would be the plain and strong likelihood of death.
I don't think that's true, because there's other evidence that there was, by a ballistician, that the way the trigger mechanism was very like a hair trigger.
No, but I'm saying if it went, he created the risk, he created the situation by pointing it right there. If it went off,
created the risk, it would go off.
And if it goes off, it does not necessarily result in death. The
That's
question is, do you give the jury the opportunity to decide that? I mean, the appeals court seems to be focusing on that. All the rest of the stuff about accident, I don't think is very interesting.
I don't think it makes any difference. I think the question is, when you point a gun in a car, are there two alternatives? The appeals court said, yes, there was significant evidence that there are two alternatives. The jury weren't given the opportunity to make a decision based on those two alternatives. And that's what the problem here. That creates a substantial risk of a miscarriage of justice. And that's why the case should be reversed.
Thank you, Mr. Rosenfeld.